The business records exception to the rule against hearsay when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallagot.com. Your advantage if you're being sued by debt collectors. As you may recall, an out-of-court statement introduced for the purpose of proving the contents of the statement are true is hearsay. And hearsay, sometimes popularly called he said, she said, is normally not allowed. There are some exceptions to this rule, however, and the most important one of these, from the point of view of debt litigation, is the business records exception. If you're going to defend yourself, the debt collectors are almost certainly going to invoke this exception, and if you can prevent it from applying, you will almost certainly win your case. The business records exception in the Federal Rules of Evidence is located at Rule 803, subsection 6. Most or all of the states have adopted this rule, so for analytical purposes it's a great place to start in this video. Before you go to trial, however, and before any point where evidence will be important, i.e. for a motion for summary judgment, you need to look up the rule in your jurisdiction. It is very likely the single most important rule in the whole case. So I repeat, if you can prevent it from applying, you will likely win at trial. If you can't, and the case goes all the way to trial, you may very well lose. It's that important. The business records exception allows a party to use records which were created, 1. At or near the time the recorded event occurred, 2. By or from information transmitted by, 3. A person with knowledge, 4. If kept in the course of a regularly conducted business activity, and 5. If it was the regular practice of that business entity to make such records. That's not so complicated, but let me give it to you in plain English. When the record has to have been made near the time that whatever they were recording, let's say a payment was made, the record has to have been made around that time. They can't have waited a week or so. 2. By or from information transmitted by, 3. A person with knowledge. That means that it has to come from information that was transmitted by the person receiving the payment or with direct knowledge of the payment. 4. If kept in the course of a regularly conducted business activity, meaning that had to be the normal process of business, okay, or the normal course of a regularly conducted business activity of collecting your payments and marking them down. And 5, if it was a regular practice of the business entity to make such records. So again, in the case of a credit card company, it would be the regular practice of the business entity to make records of the payments received. Under certain circumstances, however, none of these things can really be taken for granted. They all have to be proven. And now, a sixth requirement of the rule is that 6, shown by the testimony of the custodian or other qualified witness. That means someone who takes care of the records or is otherwise qualified, who knows about the records, or is established by certain documentary evidence. That'd be an affidavit, probably, from the person with knowledge of the records. The debt collector must prove every aspect of the exception in order to use it. So what business records will this apply to? The records a debt collector will want to use are the records regarding how you generated the debt in the first place, and any billing or payment records. Remember that the debt collector must prove that you owed the money in the first place and that you haven't already paid it off. The only way they can do that is either by your admitting it all, are you crazy, or using the original creditor's records, or having the original creditor testify. If another debt collector has been involved, let's say your debt collector is the second owner of the debt, then I've argued that they must also prove that you didn't pay the other debt collector. But for present purposes, let's just consider the original creditor. The original creditor, if it was any kind of sophisticated business entity, will at one point have kept careful and complete records of the debts and all your payments. And you might think that it would be easy for the original creditor to hand over all these records along with an affidavit by a records keeper to your debt collector. But it turns out that the process often breaks down because of the scale of the transactions. The debt collectors often buy accounts with debts totaling many millions of dollars, hundreds or thousands of accounts. And the accounts may be old enough so that even the original creditor may have lost some or all of the records. Usually, the original creditors apparently do not include a records affidavit along with the sale, and perhaps it's because they're only receiving a few cents per dollar owed, or maybe it's because of the general anonymity of the auction process. And certainly it has a lot to do with the fact that most people sued do not require any proof of the debt at all because they don't defend themselves. In any event, the debt collectors usually start out without records or affidavit, and a lot of the time they can't get one. You want to push your discovery home before they have time to go to the trouble and expense of getting one. Notice that a computer summary of the debts was not created at or near the time the recorded event occurred, but in fact, any such record would rely on other records. The debt collector's computer-generated summary, therefore, should not come in under the business records exception, even if it was generated by the original creditor. Anything relied on must come in under the business records exception or some other exception to the hearsay rule. And here's an important note for you to store in your head. Most jurisdictions require that a party offering an affidavit to prove that the business records exception applies provide you notice in advance of their intention to use a sworn statement that would satisfy the business records exception. In plain English, that means if they're not going to use some person physically to testify about the business records, and they almost never can do that, they're going to rely on an affidavit. And most jurisdictions have a rule that requires that a party that is going to use an affidavit to prove the business records exception, they have to give you notice in advance of their intention to do that. And that time in advance could be fairly significant, so you need to know that rule. You should know the hearsay rule, the business records exception, and the local rules regarding notice requirements by heart. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms. If you appreciate this video, please take a second and like it on YouTube, subscribe and friend me on YouTube, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.